So at this point, the biggest problem is not having the phone. The whole hearing was about turning over the phone by 10 a.m. today. It seems like we may never see the phone, or either side at this point will ever see the phone. In talking about the conversation, the text conversation that was happening at the time of the incident, the defense attorney is really poking at it. Seems like it was cherry-picked, the parts of the conversation that were left in and left out, saying that "help me," for example, was left in and other parts of the conversation were left out. Of course, this is not the trial, but it almost seems like, again, as you said, the groundwork for what the defense will argue.
And that's precisely right. What we have is a claim that all of the inculpatory information, all of the evidence that would tend to suggest that Mr. Spacey is guilty, is left in the messages, and all of the exculpatory information, the information that would otherwise undermine the government's case, has been removed. And the hearing that we're watching is really a hybrid hearing. It began before the first witness was called as a show cause hearing, as in show cause why the telephone was not produced. But what the judge has done, because eventually it will have to be done, is we're essentially having the evidentiary hearing portion of a sanctions hearing. And for that, the judge has a number of different things he has to figure out. Firstly is, was there a reasonable probability that there was exculpatory evidence on the phone? What's the Commonwealth or the government's culpability for the failure to produce the phone? And then ultimately, what's the prejudice to the defense as the judge decides what kind of sanction, if any, will ultimately be appropriate?
How much do you think this is about whether, or what, I should say, what was in those deleted text message versus who deleted them and why? Because those are two big issues that are weighing against each other right here.
So the answer is really both. If the text messages themselves, the ones that were deleted and destroyed, are purely innocuous, they're about the weather and what he had for dinner that evening, then there's no prejudice to the defense. But certainly the who destroyed them is very important as well, because if they're destroyed by someone who's sort of acting as an agent of the government, acting as an agent of the Commonwealth, the person who's sort of motivating the prosecution, then that can go towards the relative culpability of the government as the judge determines the sanctions.
As they took the break before we came on, the defense attorney was talking about potential penalties for deleting any messages. If you could talk a little bit about that. And he's talking about penalties to the accuser and family at this point.
Yes, and counsel read verbatim our Mass General laws as to what statute precisely that would be a violation of. Is it true that if all of that were to be true, that would give rise to some potential criminal liability? Sure. It would be a really unusual circumstance for a victim or an alleged victim to be charged with a crime, even in circumstances like these. And there's public policy reasons for that we don't want victims out there to be afraid to come forward because they fear that they're going to be the ones sitting in the defense seat if they simply lose the case.